Welcome to the boilerplate that you need to understand. What the heck is boilerplate anyway? Every legal agreement that you sign that's a formal legal agreement is going to have boilerplate terms that you need to understand before you sign them. Because while they may just look like a bunch of words on paper, they're actually meaningful terms that will impact you if and when you have to enforce the contract. Some of the terms that every agreement should have are terms regarding the length of the contract and how it can be terminated, by who, and under what circumstances. Make sure to look for this. It's usually in the boilerplate terms regarding intellectual property. Who owns it, how does it get handled, and whether it can be used by one or both parties. If you're the creator of intellectual property for a client, you want your boilerplate to provide that you own the intellectual property you create until the contract is paid in full. If you're the employer of someone creating intellectual property for you of any kind, including written word, image, or computer code, well, you want the boilerplate to provide that once the agreement is paid in full, you own the intellectual property created for you. This is called a work for hire provision. And if your agreement doesn't include it, you're at risk of not owning what you paid to have created for you. This is because under copyright law, creators own the copyrights to any works that they create. Most agreements will have boilerplate terms regarding non-solicitation, meaning that one or both parties can't solicit work with contacts made as a result of their relationship. It may also include non-competition provisions that provide limitations on future work that can be done after the relationship is over. It is critical that you understand the non-solicitation and non-competition terms that you're agreeing to when you sign an agreement. And this happens in the boilerplate terms I'm speaking about right now. Your contracts may include provisions regarding refunds and under what circumstances one of the parties can seek the return of consideration. Remember, consideration is the money exchanged under the agreement or terms of the contract. If you're selling products, your agreements need to cover the terms under which someone is buying your products. For example, do you provide refunds in a way that makes it easy for your customers to review the terms of your refund process if they don't like what they bought? Or maybe you simply clarify whether you even provide refunds. Maybe you don't. You need to make this very clear, and that usually happens in the boilerplate terms. If you're selling services, you may want to include boilerplate terms regarding chargebacks to a credit card. All agreements should have provisions for conflict resolution, including how conflicts will be resolved, where they will be resolved, whether you must agree to mediation or arbitration before a lawsuit can be filed, and who will cover the legal fees in the event a lawsuit is necessary. These are all provisions that you should look for in the agreements before they are signed. These are all terms that can be negotiated. If you ever ask to sign an agreement in which you don't understand the terms, ask for help. Ask for support in our Black Wall Street membership program, or ask your personal Black Wall Street corporate counsel. There are no stupid questions when it comes to agreements. The only stupid question is the one not asked, especially if you signed an agreement you didn't understand because you were too afraid to ask for clarification. So ask before you sign, because once you sign, it's too late. And even if it is a boilerplate term, you agreed to it. So learn exactly how to review an agreement before you sign it, and what all those boilerplate provisions look like and what they mean.